The nature of international law, the history of international law. The roots of international law run deep in history. In early religious and secular writings, there are many evidence of what we know as international law. There are, for example, the detailed peace treaties and alliances concluded between the Scyths and the Romans, Syrians, and Spartans. The Romans knew of ius gentium, a law of nations, which Gaius in the 2nd century saw as a law common to all men. A universal law that could be applied by Roman courts for foreigners when the specific law of their own nation was unknown and when Roman law was inapposite. In the 17th century, the Dutch jurist Hugo Grotius argued that the law of nations also established legal rules that bound the sovereign states of Europe, then just emerging from medieval society in their relations with one another. Grotius' classic of 1625, The Law of War and Peace, is widely acknowledged, more than any other work, as founding the modern discipline of the law of nations, a subject that in 1789 the English philosopher Jeremy Bentham renamed international law. Nowadays, the terms the law of nations and international law are used interchangeably. At least since the end of the 30-year war in 1648, world politics has principally involved the relations of more or less independent sovereign states. An important part of international law has consequently had to do with the establishment of a set of mutually agreed upon rules respecting the nature of these states and their fundamental rights and obligation inter se. And there is a single international legal principle underlying the modern state system. It probably is the one neatly framed by Montesquieu in 1748 and offered to Napoleon in 1806 by Talleyrand. That he said that nations ought to do to one another in peace the most good, and in war the least evil possible. International law is sometimes conceived to be divided into public and private parts. The first concerning the legal relations of states, the second involving the law governing the foreign transactions of individuals and corporations. However, the public-private division of international law can be misleading. Many of the laws processes traditionally within the ambit of public international law actually concern private, not public, parties, while much of the domain of private international law covers the transactions of public entities. Nonetheless, the terms public and private international law are highly popular, and in the rote kind of way do compartmentalize legal rules addressing two problems areas. Public international law mostly concerns the political interactions of states. Private international law relates to legal aspects of the international economy and conflicts and cooperation among national legal systems. Few deny that the rules that of international law actually influence state behavior. Even international law's most famous jurisprudential critic, John Austin, acknowledged in 1832 that international legal rules were effective. At the same time, however, he argued that because there was no international sovereign to enforce it, international law could not be the same sort of positive law as that enacted the sovereign state for internal application. The law obtained between nations is not positive law. For every positive law is set by a given sovereign to a person or persons in a state of subjection to its author. As I have already intimated, the law obtained between nations is law, improperly so called, set by general opinion. The duties which it imposes are enforced by moral sanctions, by fear on the part of nations, or by fear on the part of sovereigns, or of provoking general hostility and incurring its probable evils in case they shall violate maxims generally received and respected. Just a few years later, in 1836, the United States diplomat Henry Wheaton, in the first great Anglo-American treatise on international law, was already grappling with Austin's characterizations of the rules governing international politics as being a form of mere morality. Wheaton accepted Austin's view that international law's principal sanction was the hazard of provoking the hostility of other communities, but contended that the experience shows that these motives, even in the worst times, do really afford considerable security for the observance of justice between states. If they do furnish the perfect sanction annexed by the lawgiver to the observance of the municipal code of any particular state. Unlike Austin, Wheaton found international law sufficiently law-like to justify calling it law. Definitional outcome reached by generations of subsequent international lawyers. Whether the international rules regulating under interstate behavior are to properly termed legal or moral, is in truth of a question that can only be answered after one has made more or less arbitrary definitions of what really constitutes law and morality, sometimes sterile exercise, of course. Yeah. Suffix it to say at this early stage of our own discussion that there are a great many rules regulating international politics, economy, referred to as international law, and that these rules are usually, for one reason or another, observed in international practice. Moreover, there is no doubt that the norms of international law are frequently applied as rules of decisions by law courts, domestic as well as international. The rules of international law. We know reasonably well how to identify rules of municipal law. The term used by international lawyers to denote the internal laws of national legal systems. Municipal rules of law generally are through to emanate from national constitutions, municipal statutes, executive regulations, and decisions of municipal courts. Oftentimes, the possible sources of municipal law include not only formal legislatures, but also other political structures, when these institutions are accepted to actually generate rules of law. Of course, municipal legal systems differ among themselves, and what may be a source of legislation in one country may not be so in another. So, for example, law courts are through are for to be makers of legal rules in the United States and not in France. In international law, the identification of legal rules is quite different, and it is in most municipal legal systems. The reason for this is directly linked to international law's very nature, given to international political system of nation states, and the idea of state sovereignty. The sources of international law cannot be equivalent to those of most domestic laws. There are only occasional international imitations of national constitutions, parliaments, executives, and courts. For example, the United Nations system offers only skeletal international governmental bodies that have just begun to be fleshed out in practice. This is not to say that some international organizations, especially rational ones such as the European Union, have not come close to creating municipal-like sources of international law. I am not sure if it is municipal, I think. Municipal, I don't know. So, given the rarity of effective formal international legislative executive and judicial organs. Some have said quite simply that international law does not or cannot exist, and that the only real rules of law are those generated by sovereign states for their own internal consumption. The trouble with such a simplistic assertion is that it contradicts centuries of practice during which governments, courts, and others have, for one reason or another, found and applied rules of international law. Traditionally, rules of international law have been identified by looking to the various forms of rulemaking conduct of two or more states, although these different forms of conduct tend to blend one into another. It is helpful at the outset to think of each form as a discrete source of a certain sort of international law. The first and plainest source of international law is the explicit, usually written agreements that states make among themselves. These agreements are often labeled treaties or conventions. Municipal law analogy to this source of international law is, of course, the idea of contract. Like contract treaties are capable of creating voluntary, though legally binding relations. These are sometimes known as conventional international law. A second source of international law is customary practice, other than the making of treaties of states among themselves. Such international customary practice has municipal analogies in commercial law notions, such as the course of dealing and the usage of trade, where practice creates justifiable expectations of future observance. So international practice is though capable of creating binding rules of law known as customary international law. Greater difference in conception from the international practice of a state as a source of international law is the general municipal practice of a state. The idea is that if most of or all states observe certain rules as part of their domestic laws, then it may be presumed that these rules are so fundamental as to be more or less automatically a part of international law. Such rules deriving from reflecting the common municipal laws of a state are known as general principles of law, of course. Note how at last the first two sources of international law may be said to emanate from the consent of a state. With conventional international law, the states that are parties to the treaty explicitly agree to be bound by certain rules. With a customary international law, their consent is implicit. To be found in their international practice. The consensual notion is, however, not the only possible justification for believing that treaties and custom are proper sources of international law. Some have said that these forms of state conduct are simple manifestations of rules that are bound to exist regardless of state consent, and that beyond general principle principal rules of law, principles of law, there are other sorts of non-consensual rules of international law. So behind such non-consensual ideas lie notions of natural law that have been more or less fashionable over time. Debate between natural lawyers and positive lawyers is long-standing in international law. So what do you want to say when you talk about positive lawyers? Are those who insist on the positive rules of a state are called. So this Sancter it is more or less immaterial to decide whether positivist or naturalist notions better justify treating state agreements and practice as sources of international law. These sources, at least being agreed to be sources all the same. In practice, lawyers, whether positivist or naturalist by persuasion, look at the wide variety of evidence to find, apply, and develop rules of international law. In this search, there is sometimes no bright line dividing the evidences of the different sources of international law. For example, a provision of a treaty that may be an evidence of a state custom in general, as well as an evidence of a particular state agreement. It is usually true that the evidences of customary international law are more diverse than are those of conventional international law or general principles of law. Some usual evidences of customary international law are in no particular order: constitutional, legislative, and executive; promulgations of state reclamations, judicial decisions, arbitral awards, writings of specialists of international law, international agreements and resolutions, and recommendations of international conferences and organizations. So, evidences of conventional international law include the written agreements themselves, to a lesser degree, material related to the drafting and conclusion of the agreements. Furthermore, it may sometimes be necessary to interpret international agreements in the context of international custom, in which case the extensive body of evidences available in finding customary international law becomes relevant to the finding of conventional international law as well. Evidences of general principles of law include municipal laws, doctrine, and judicial decisions.